Good evening, Advocate Basson.
Good evening, Chief Justice.
How are you, sir?
I'm very well, thank you, Chief Justice.
I want to take this opportunity to apologize to you and to apologize to colleagues from NADLEC that we have kept waiting for a rather too long period. I'm very sorry for the inconvenience that we have caused you.
Chief Justice, that's one of the similarities between politicians and legal practitioners. We don't keep to regular working hours.
Thank you, sir. Thank you. You hold 3 degrees and you are now busy with a Doctor of Laws degree. Am I right? No. I'm sorry. I'm looking at the wrong thing. I'm sorry. I apologize to you, Mr. Basson. You hold 2 degrees, PLC and LLB.
That's correct, Chief Justice.
Now, what did you do upon completion of your degree? The last one.
Chief Justice, I did my BLC and immediately thereafter started a career in the civil service at the Government Employees Pension Fund. While I was working, I did my LLB part-time and I paid for my LLB whilst I was working as a public servant.
And for how many years have you been practicing as an advocate?
Chief Justice, I spent 8 years at the Government Employees Pension Fund. I then joined the bar in 1999, and I've been a practicing advocate for 21 years now.
Yes. And I can see that you've acted as a judge, you've attached judgments here. Am I right?
I have, Chief Justice. I've acted 3 times on a pro bono basis during recess at the Labour Court.
Yes. And have you had a challenge producing a judgment within the stipulated period or the recommended period?
Chief Justice, the judgments I prepared were delivered on an average between 3 and 5 weeks after argument was heard. There was one matter which I could trace back, which was a review with more than 5-6 lever arch files, and in that matter I exceeded the 3-month norm. So there was one judgment which I could trace, which took longer.
Yes. No, thank you. Thank you very much. JP, welcome, my brother.
Good evening, Chief Justice.
JP? Yes. I have unfortunately not been given the names of the NADLEC representatives. Are you able to assist me, JP? I'm sorry to do this to you. It is the officials who should have done this.
Sorry, Chief Justice. There are only 2 persons from NADLEC. One is authorized by the other as well. The 2 persons are Mr. Kalipi and Mr. Lukele, who's a new member of NADLEC as far as the JSC is concerned.
All right. Okay. All right. Colleagues, let me have the names of those who have questions for Advocate Basson, please.
Singh.
Shlema.
Thank you. Judge President, over to you, sir.
Thank you, Chief Justice. Mr. Basson, welcome, and I just have a few issues. Firstly, we talked about judgments. Let's talk about the one judgment, which was reversed. That's Samenko. You know that judgment? You remember that judgment at all?
Yes,
I'll
I do.
tell you what the issues I have on that one, because there seems to be lots of debate going on from people who commented on your position here. And that is, I'll tell you what my issues are, and maybe you can respond. You pointed to here the review in Samenko. In that matter, the arbitrator had decided that of the 4 people who were charged, there were 5 people in a team who failed to carry out an instruction. 1 was acquitted, 4 others were charged, found guilty, and the arbitrator said, but we cannot dismiss them because the 5th person was not dismissed, and she was part of the team. And this was inconsistent application of the sanction. And that was the arbitrator's decision. It was taken on review, and it came before you. Now, if you remember what you decided, for some reason, on 3 occasions in that judgment, and it's very curious why you did that, but on 3 occasions in the judgment, you've made the point that the 5th person who was not found guilty of failing to carry out the instruction was the girlfriend of the supervisor who gave the instruction. And then you go on and you make the decision that the arbitrator was right, but you don't talk about the consistency or inconsistency. You say, on the facts of this case, it wasn't proved that these 4 people had committed the offense. There wasn't enough evidence. Is that right?
That is correct, JP.
And the matter was then taken on appeal
That is
on the Labour Appeal Court. And the Labour Appeal Court, if you remember, said they were in fact very intrigued that firstly, you didn't deal with the cardinal issue, main issue, which was really inconsistency. That was the issue. You didn't deal with that at all, although you mentioned 3 times that the person who was not dismissed was the girlfriend of the supervisor. And then you say on the facts of the matter, they had failed. And the LAC said they couldn't understand that because the facts were very clear and these people had failed to comply with the proper instruction. And they reversed the decision of the arbitrator, if you remember, because they also said there was no issue of inconsistency because a 5th employee was never in the team. She had been sent by one of the team members away at the time when the supervisor came and gave the instruction. Isn't that so? Now, I find the problem I have, and you can respond to that. In terms of law, sometimes there's interpretation, and if there isn't precedent, then there can be difference of opinion. But when there is a problem where the facts are seen so differently, the arbitrator and the LAC saw the facts in one way, and you saw it in a different way, and the LAC went to a lot of trouble to say why you were wrong. Now, I have a concern when an acting judge, or any judge for that matter, gets the facts wrong. What comment could you have to make on that? And I raise that because you have raised this judgment in your questionnaire.
Yes. JP, I particularly pointed out that judgment because it was the one that was taken on appeal and overturned on appeal. The facts as it was argued during the review mainly concerned the question whether there was an instruction given to the employees who were busy mining. There were 2 instructions, and it concerned the second instruction and whether they failed to comply with that instruction. I found on the evidence in the review that there was insufficient evidence presented by the employer to prove that there was in actual fact misconduct or a breach of their duties. And it is on that basis that I found that there was insufficient evidence and therefore that the dismissals were unfair. The issue of consistency was not that pertinently raised during the review. I see that it was in fact pertinently raised in the appeal. And that is also one of the issues that was pointed out in the report by the GGRU. It is correct. I made a certain assessment of the facts, and the Labour Appeal Court came to a different conclusion on the facts and also the issue of consistency. In my defense, and as pointed out by the DGRU, the issue of consistency was not that pertinently raised during the review.
But that was the basis on which the arbitrator had made the decision. We'd not go debate that much further, but wasn't that was really what the point raised by the LAC. That was what the arbitrator depended on, and that's why they needed some response from the judge on that. In any event, when you say that you came to a different conclusion, the issue was this, and that's what the LAC also said, that how you see the facts didn't really matter. This was a review. You had to see how the arbitrator, why did he come to that? Because the arbitrator found that they had misconducted themselves, you see. But okay, as long as we have an idea and I understand what you're saying, but those are my difficulties which I raise, then tell me about the matter of Carmichael Brown. Did you act for Carmichael Brown? I'm not sure. Or
I did, JP. Yes, on 2 occasions. There are
on 2 occasions. The one occasion was the issue of the subpoena. Is that correct?
That is correct, yes.
And you are, and I suppose not you, but your attorney would have issued a subpoena, and the other side objected to the issue of the subpoena, which then came to court. Am I right?
It's the other way around, JP. They issued the subpoena.
And you objected?
We objected on the basis that there's a distinction between discovery and the subpoena. The subpoena was issued against the other litigating party. And we took the view that a subpoena ought to be aimed at a witness, and that the ordinary discovery process is applicable when you want documentation from your other litigant.
Yeah, that's what I was worried about. And you're absolutely right. You need to use discovery. But the other party, was it part to the pleadings, party to the matter at least? Was it a party to the action?
Yes, the subpoena was issued by the one litigant against the other litigant. That's correct, yes.
Okay. Yeah, that's fine. And were you involved in the other matter relating to making an agreement, an order of court? I think that was before me. I don't know if you were the counsel in that matter, which was, I think, Correctional Services or Ministry of Justice. I'm not sure. Were you involved in that one? I know there was a Basson, and I wasn't sure if it's you.
I can't recall that,
Yes,
JP.
That's fine. Then I want to ask you something about your studies. I mean, I noticed that you went to university at the age of 17, is it?
Yes, my wife always joked that my parents wanted to get rid of me as soon as possible. I went to school at the age of 5.5 and completed matric at the age of 17, yes.
Did you not do your military service?
I did not, no.
Oh, okay. And I see you have no involvement in any community issues at all, according to your questionnaire. You don't involve yourself in any community matters.
No.
I suppose you practice all the time.
Yes, that's the difficulty of being in full-time practice, is that there's not always a possibility of being involved in community service and in other organizations where you would like to be.
Okay, thank you. Chief Justice, that is all from me.
Thank you, Judge President. If you could switch your mic off, please, JP. Mr. Mkalipi and Mr. Lukele, again, I just want to apologize to you directly for keeping you waiting as long as you have had to wait. I'm really sorry about that. Who of you is going to put questions to candidates?
Chief Justice, thank you for the apology. We understand That's how these things happen with interviews. It's difficult
Thank you
to
so much.
pick up time.
Thank you.
And from my side, from Advocate Basson, I'm fine at this stage. I don't know about
Thank you.
Sifiso.
Thank you. Is it Mr. Mkalipi?
That's him.
Thank you, sir. Thank you very much for understanding. Honorable Singh?
Thank you very much, Chief Justice, and good evening to the JP and the representatives of NADLAC and Advocate Basson. I just have one question that I'm trying to get an understanding of from your questionnaire and your CV. I see you've got quite a bit of experience in labor law issues. But according to what I have here, you seem to have acted pro bono, which we thank you for only 12 days, from the 9th of July to the 13th of July 2018, which is 4 days, 8th of July 2019 to 12th July 2019, which is also 4 days, and then 15 July to 19 July, which is also 4 days. Now, I don't know, perhaps after you completed this form, you might have acted again, but am I correct to say that you only acted for those 3 terms and for 12 days?
That is correct, Commissioner.
Thank you, Chief Justice, and thank you, Advocate.
Thank you very much, Honorable Singh. Professor Schlemmer?
I'm covered, CJ.
Thank you very much, Prof. Advocate Basson, you are excused, sir.
Thank you, Chief Justice.